We have a valid order to remove this guy. So don't tell the court that we're using this power to do it. We're not using the AEA, we're using the INA. So why are you telling the judge that we're using a different provision of the law when you know it's different? Regarding where they were removed to, or if they're killed, or if they're removed into the ocean. TikTok brain. He contended the government's removal of Lore was in contempt of court. Then he attacked this court, contending that this court's best not to catch the eye of the president or his supporters, ripping the court. The Trump DOJ now demanding sanctions. And this one's a little unusual because it's sanctions personally against an individual immigration lawyer. Okay, this immigration lawyer called Joshua Schroeder, they say is an immigration lawyer from California who just came skidding into this case. And he's like, I'm going to represent this illegal alien called Vang and file a bunch of motions. Now he is getting hit with a demand for sanctions. And you can see the DOJ said this guy was filing frivolous motions and was acting a fool. And so he needs to be penalized for this. As a deterrent, he needs to be hit with fines for wasting everybody's time and filing a bunch of bad motions. They write, all right, judge, listen up. This petitioner's counsel is called Joshua J. Schroeder. And he, this attorney on behalf of this client, is acting in bad faith, unreasonably, and vexatiously multiplied proceedings by maintaining positions without basis in fact and law, without making a reasonable or competent inquiry and for an improper purpose, with no evidence in support or with knowledge to the contrary. This lawyer came out and he argued the government was removing this guy called Vang Lore under the AEA. He came into court, Your Honor, they're going to throw my client out of the country. But he knew that wasn't true, says the Trump DOJ. That was false. In fact, Lore had instead been convicted of attempted murder and was being removed under a final order of removal that was issued under the INA. Okay, we have a valid order to remove this guy. So don't tell the court that we're using this power to do it. We're not using the AEA, we're using the INA. So why are you telling the judge that we're using a different provision of the law when you know it's different? Schroeder, nevertheless, this lawyer, persisted, says Trump's DOJ, in making frivolous arguments for the improper purpose of forestalling Lore's lawful removal to Laos in not only this court, but also in the district court for Texas and also the Court of Appeals for the Ninth Circuit. So this dude just filing motions everywhere to stop this guy from getting deported because he's an attempted murderer. His vexatious conduct has cost the American taxpayers, this lawyer, a lot, requiring the government to respond to repeated, patently meritless filings in 3 separate courts to take Lore off his original flight to Laos, to hold him in custody for days, and to arrange new travel to Laos once this court dismissed his meritless petition. Okay, we had to drag this guy all over the place because this lawyer was just filing like a fool. This court should sanction Schroeder's conduct. Trump's DOJ says it should impose sanctions to deter Schroeder from continuing to multiply baseless proceedings. And given the nationally important need for the government to, enforce the law, sanctions are essential for general deterrence of misconduct. And you start hitting these immigration lawyers with big fat $10,000 sanctions. We'll see if they keep filing pro bono for all these illegals. As the president has explained, the immigration system is replete with examples of unscrupulous behavior by attorneys and law firms, behavior that thwarts the ability to carry out the will of the people. So here's the background. Lore is this person that Schroeder is representing. He's a native of Laos, and he was admitted to the United States as a lawful permanent resident in 1987, so legally here. But then in 1998, he pleaded guilty to attempted murder. Oh, that's good. Glad he came over here. 22 years imprisonment. So then, after he's in prison, in February 2018, Homeland commenced removal proceedings under the INA. They served a notice to appear on Lore. They filed it in immigration court in California. That notice said, you're removable. You committed an aggravated felony, and so we're throwing you out. In March, he appeared pro se. Okay, so he represented himself in a proceeding before an immigration judge. That's called due process. He affirmatively waived his right to counsel, and he answered the notice. He denied that he was a citizen there, but admitted he was born there, and corrected the allegation that his prison term was only 9 years, is what he said. Now, after the immigration judge heard the evidence, found Lore removable, and directed his removal. Now, he disclaimed any fear of being returned to Laos. He affirmed he wished to be removed there, all in the proceedings. The immigration judge asked further questions to see if Lore might be entitled to any other relief. Are you being abused or being tortured? No. Okay, well, all right, you're gone. The immigration court again said, are you sure you don't want to get a lawyer before you go? He says, no, I don't need a lawyer. I just want to get this over with, okay? I conclude my case. I waive my right to appeal. Send me back to Laos, and that's fine. Lore was accordingly ordered removed. So he got due process. They said goodbye. So then in March, Trump wins. The president issued a proclamation invoking the AEA. He said Trinidad Aragua gangbangers must go. But Lore, this person person was never designated an alien enemy, and he could not be, given his Laotian nationality. Now, in April, Lor was detained by ICE. April 2025, not long ago. He's picked up. On May 24th, he called his wife, called Now Zhang, to tell her. He said, hey, honey, I'm getting removed to Laos. They caught me. She says, oh no. On May 25th, she goes and hires this lawyer. So he goes wild. He files a bunch of motions saying he filed a petition for a writ of habeas corpus in Texas, which had jurisdiction. That's the right location. Now, he also represented, he said, well, it's not exactly clear to me what his immigration status is. He's, I don't know. The petition said, though, Lor has had no due process, because that was the stupid line that all the ACLU lawyers were saying. Due process, due process, due process. What do you think appearing before a judge is? Saying he had no chance to be heard before an impartial decision maker. Yes, he did. How could you put that in a pleading? The petition alleged that Lor was being held in actual or constructive military detention and was being treated as a prisoner of war, says this lawyer, and that removal appears to be an extraordinary rendition without any process notice or known legal basis. It identified 20 claims of relief, each one tied to the AEA and the proclamation, which he was not even detained under. Shortly after the petition was filed, the lower court ordered the government not to remove this guy because the judges are all freaked out. Like, when you're a lawyer, you have a duty of candor to the court. You got to be honest. You can't lie, and you can't overly exaggerate things. You can advocate for your clients and argue within the confines of reason and rationality. But if you start to exaggerate things and you're like, he's being waterboarded by Tom Homan in Texas. What are you talking about? No, he's not. So how dare you say something like that to the judge? And the judge is going to say, well, you have a duty of candor. You're licensed. You should be acting honorably and honestly. They accept it. What are they supposed to do? Now, Schroeder then filed motions for a TRO and class certifications, and he was inspired by the ACLU. He's like, yeah, they're doing it. I'm going to fight too. On May 26th, the government made an emergency request to clarify the court order. They say, all right, so we can still remove him because he's suing under the AEA, but we're not even using the AEA. So grant whatever he wants. We're not even using it. Rather than this, because we're removing him under the INA, they sent in his removal order. They said, well, he appeared. Here's his criminal records. Our case is airtight. The government further explained that you're going to make us fly him around and fly him back to Guam and all this stuff. Like, we're removing him. The plane carrying this dude landed at Guam at a planned stopover. And because the judge came out and issued an order, the government left him there in Guam. The flight continued to Laos without him. The government housed him at a detention center down there. And I'm sure that's not really enjoyable for him. Like, the dude wanted to go to Laos, and now his lawyers are like keeping him in Guam. Presented with evidence of his removability, then the Northern District of Texas denied the motion. All right, so once they stalled and stopped this whole thing, and he's now stopped up in Guam, then the documents come through, and the judge is like, oh, wait, he did have due process, and there's a valid order? Then why'd this lying lawyer say differently? Finding that Lor had not shown a likelihood of success because the government's evidence said he was not being removed under the AEA at all. It was the INA. So the court said, oh, well, we got a valid order, so I guess take him out. So Schroeder then filed a renewed motion. This lawyer says, I'm not done yet. He continued to invoke the AEA. He says, well, I'm going to just invoke it again. He argued that the INA was intertwined with the AEA. He says the same thing. He further said the government had transformed immigration enforcement into a military matter and was giving immigrants no notice or opportunity to be heard regarding where they were removed to, or if they're killed, or if they're removed into the ocean. TikTok brain. All the people on Democrat feeds saying that Trump was throwing illegals out of an airplane into the Pacific. He objected that Lor's removal order or into the Gulf of America. He objected that Lor's removal order had not been served on Lor's counsel and that had no notice had been given to any of this. He said the government violated the district court's order too. Like, the guy's just going nuts. Now, on May 27th, the government responded. They said it was meritless and bordered on nonsensical for this lawyer to recast as a violation of Lor's rights or comply. We literally complied with the court order. We took him off the airplane in Guam. What else do you want? Now you're mad at us for that? The government provided additional evidence that he got notice. We told him he was being removed. He had plenty of notice. And we observed that Lor could have challenged his removal at any time. But now he's gone. And now you don't have jurisdiction over this. So then the lawyer came back, filed another emergency motion with the court, not letting up. He's inspired by the ACLU people, seeking a transfer of venue to another court or a dismissal. He then criticized the district court. He said, how can you allow our jurisdiction to be destroyed? Government responded, you're meritless. And because Lor was in Texas, that's where the district is. He's in Texas. That's where he's housed. That's where the habeas is filed. So then Schroeder replied. He contended that the case could have been filed in Guam if the government had given previous notice that they were going to take him off. He accused the government of subterfuge in its venue argument, characterizing the argument as an admission that the writ of habeas corpus had been suspended, and the guy just goes nuts. He insinuated insinuated that the government intended to lie about removing Lore, instead subjecting them to death by firing squad, marooning them on deserted islands, or drowning them in the sea. All right. And he again accused the government without any evidence or contrary to the law of intentionally destroying jurisdiction. Now, while all this was pending, Schroeder filed another petition, basically the same here in a different court. He continued to assert his claims even after we gave him evidence that he had a removal order under the INA. And he even spoke with Lore by phone, and he was working with his immigration lawyer. Now, then he filed an emergency motion in this court. The motion again said you can't remove him. And the motion made false claims. He said Lore was not given notice about why he was being removed. They said, we showed you the document that we gave him that he probably signed. Did you get notice of this? You understand it? Yes, really? Yes, I signed it. Here it is. And not given a chance to rebut those allegations. Now, in an attached declaration made under penalty of perjury, this lawyer said, Schroeder asserted that his criminal history and his immigration status were unclear to him. Nah, that's not so good. His declaration did not mention the evidence of Lore's criminal history or his removal order that was already given to this lawyer, nor did it explain why that evidence was so doubtful and why it made it unclear. It's very clear on its face to everybody except this guy. And although Schroeder stated that he had personal knowledge of the facts stated in the declaration, he said he made several statements on knowledge and belief, on information and belief. He's got no basis for that information or belief. That there were people similarly situated to Lore in another group of Venezuelans who were also flown down to El Salvador. He also filed a motion for a class certification. He said that Lore's claims were typical of a class and it should apply to everybody. But man, he got carried away. Now on June 3rd, in response to this, Schroeder argued that personal jurisdiction was lacking because he's in Guam. And then Texas dismissed the habeas. They said, no, your claim is gone, so get out. Noting that his filing did not even address the argument that you don't have jurisdiction. He's gone, so you don't have jurisdiction anymore. The district court further found that Lore and Schroeder lacked a basis in law and fact to seek relief. Schroeder did not withdraw the petition, and his pending motions are still going. So then on June 5th, the government responded to the TRO. The government also opposed class certification. Schroeder replied. In the reply, he said the government's evidence of the removal was an unnoticed allegation and just continues to fight. Then on Saturday, the court held a hearing. He again said the government designated Lore an alien enemy. We're like, dude, how many times do we have to tell you? INA, official removal order. The court next asked why Schroeder. The court says, wait a minute, what? The court, in response to this court's question whether he was, quote, arguing in his motion here before this court that he's under the AEA, he's operating under the AEA, the lawyer said, yes, I'm here suing under the AEA. So then the court said, well, why did you, the lawyer, say that Lore did not get notice of removal? Why did you say that he didn't get notice? Because they say he did. They have a document that says he got it. So like, why did you tell me they didn't get it? They say that this lawyer didn't give a responsive answer. The court asked whether Schroeder disputed any of the documents the government had submitted as evidence. And he again gave a non-responsive answer. They said, well, he has an INA order. Like, did you get a copy of that? They said you got a copy of that, lawyer. Did you see it? Again, non-responsive. He said, well, those documents had not been given to his lawyer before the government tried to remove him. So then the court again asked the lawyer, okay, well, is the government's filing of the documents in Texas, was that the first time that he got notice about Lore's immigration history, lawyer? He said, well, no, I actually had a little bit of history because I was a California attorney and Lore's crime was committed there, right? So like, in other words, he knows how it works in California. He could have looked up his criminal record, his criminal charges, and found them immediately. But he says, I'm unclear about what it is because he's, in my opinion, lying. This court attempted to clarify the extent of Schroeder's previous knowledge of immigration history. Okay, well, when did you find out? Did you search for it? Did you look for it? Did you get his file? Did the other immigration lawyer, what was it? Continued to give non-responsive answers because he's busted. Eventually, he stated that he first received the documents via the government's opposition to his TRO in Texas. Finally, he's like, no, I learned after, okay? I wasn't dishonest at the outset. I learned about it. Now I'm discovering it. With that information, the court then said, well, what about their, okay, so now you know that he's committed of a crime and he's got a removable order under the INA. So now what's your position now that you know that? He said, well, this is not a normal immigration way of handling cases, of handling a removal. So in other words, I don't like it. And again asserted without any authority that the government should have given notice of removal to his lawyers first before they can remove him. Now, redirecting Schroeder from discussing a different case, the court's like, all right, man, I don't know what you're talking about, but I need you to answer this. Do you understand that the government's position is that the government has already provided this guy with multiple notices before they removed him? Like, do you understand that concept? You're saying there was no notice. They clearly have given him notice. He had a whole hearing about this. Do you agree? Well, he partially agreed that he was not really pushing the Alien Enemies Act. He's saying, well, but instead saying there's an exception then within the INA, kind of makes it like the AEA. He's like, all right. But he added, apparently the government cannot remove anyone to Laos or anywhere else without the sovereign consent of those nations. And that even if the removal proceedings had been proper, there would remain legal questions because the law must ensure that people aren't killed or destroyed because a removal order is not a license to kill. This court sought his concession. They said, all right, man, like they're trying to work with this dude. Do you concede that Laura's removal was allowed pursuant to the INA? So now that you have notice about it, do you concede that that was valid? If that process was followed correctly, could they remove him? He's like, well, his only remaining argument was, well, maybe, but Laos may not want to receive him. So maybe, did we check with them? Like, do they want him or not? Schroeder did not answer, instead reviving his argument that due process had been violated because Laura and his counsel were not told. This court returned to questions about jurisdiction. Again, more non-responsive answers. Asked whether his removal order stated the location to where he was removed. He said that he had not been served with the order, and I wasn't given it in any normal way. When asked whether he had received notice of removal, Schroeder, the lawyer, again equivocated, responding that he had received it through the court, but again, not in a normal way, whatever that means. So he continued to shift positions. In response to the court's statement that he's not in custody or facing removal under the Alien Enemies Act, he said, well, that's extremely unclear, and we don't know why he's being removed. He refused to agree that we actually know exactly why. It's the INA, and he repeated in his rebuttal that we can't remove him. So after the hearing, he filed a premature motion to stay the judgment because it sounds like he knew he was going to lose. Like, in other words, after that hearing, he came back prepared to filing, okay, I know you're going to rule against me, so please stay it. On June 9th, the court entered an order. Like, that hearing sounds like it was brutal. Like, he just got steamrolled there. Judge is painting by numbers through that. Okay, you understand? No, I don't understand anything. All right. So the court comes back, issues an order saying you're denied. Your petition is dismissed. Deny the motion for a stay. The court said that Schroeder's filings did not address or rebut the evidence under the INA. Didn't even address it. So then Schroeder filed an appeal to the Ninth Circuit. Even though the court had entered final judgment and had not even certified a question for interlocutory appeal, so then he starts filing and he starts going nuts. He contended the government's removal of Lore was in contempt of court. Then he attacked this court, contending that this court's best not to catch the eye of the president or his supporters, ripping the court. Schroeder filed a notice of appeal. Then the Ninth Circuit dismissed his petition because it wasn't certified. Court of Appeals denied it. That appeal is still pending. The court left in effect a briefing schedule by the notice of appeal, and so it's still going on. So the guy was just going crazy, right? Now, this court may require an attorney. Trump's DOJ is not happy about all this stuff, and this was happening at scale all across the country. So go find the bad ones, file for sanctions so that they have some skin in the game, so they know they just can't file like mad illegal lovers and impede the government. This court may require attorney's fees, and we want these sanctions to be slammed on him. There were unnecessary filings, and these are unnecessary tactics. And there are provisions that say these sanctions can be imposed personally on attorneys, especially when there's a finding of bad faith, when they're raising frivolous arguments or making bad claims, and you have an inherent power to do that. Attorneys can act recklessly, and frivolous filings are one that are baseless. Now, all of that is the rules. Now, here is the application and the argument. It says Schroeder broke those rules. As laid out above, he made myriad meritless contentions in his filings to this court, just making stuff up. Most egregiously, he said that he was being removed under the AEA, knowing that that's not true at all. That was a baseless claim, and he knew it. Schroeder also knew about the INA removal order. The government filed the notice to appear, so we gave it to him. We filed his removal order. We filed the abstract of the criminal judgment that showed what he got convicted of. 6 days. All of that were submitted as exhibits 6 days before Schroeder started his proceedings here. Then he filed his motion, making claims that he should have read the previous filings and actually reflected what was in them. Schroeder admitted in response to this court's questions that he had actual notice of this. After it was docketed, he didn't correct it at all. Even if Schroeder may have had a justifiable reason to file his initial pleading, that reason did not persist once he became privy to this, and he should have updated the courts. And he knew that Lore, who is Laotian, would not have been designated an AEA, so Schroeder had two good reasons to question this, but didn't really care. Schroeder had multiple opportunities to also inquire into this. In fact, Schroeder and Lore spoke by phone 3 hours after Schroeder, the lawyer, was served with the INA removal order, so the lawyer could have asked the client about it. If Lore indeed denied the validity of his removal order, that's not mentioned anywhere. Schroeder also could have looked up the info on the DOJ online docket for his removal proceeding using his A numbers, which was on the removal order. The docket reveals that Lore had been ordered removed by the government in a proceeding in March 2018. He did not appeal it. And Schroeder, quote, was working closely with his immigration counsel and and the immigration lawyer knows why he was removed. But even if Schroeder could not have performed any of that inquiry in the 6 days, he had ample time to do that as the case developed. He had a wealth of opportunities to follow up on the removal order, but he didn't. His equivocating responses show that he knows that his position was baseless. Here's an excerpt. Lawyer says, well, there's an allegation that Lohr can be lumped in with Venezuelan nationals. There's an allegation. Court says, so are you saying your client is being included with the Venezuelan nationals as he's being removed? Like, there's an allegation that he can be lumped in with the Venezuelans. Okay. Are you making that allegation right now or what? So are you saying your client is? He responds, and what I'm saying is that there is more than one proclamation. It's like, well, you didn't answer my question. Are you saying that that's how this applies to your client? This court can also conclude that he knew his arguments were frivolous because his behavior, as explained below, manifested the improper purpose for blocking his removal. Now, separately from his repeated baseless assertions that Lohr was being removed under the AEA, Schroeder also knew this court lacked jurisdiction in habeas to enjoin the execution of his removal. They couldn't stop us. Indeed, his assertions were showing, and they effectively meant that the writ was suspended, is what he wrote, and they indicate that he understood what he was doing. But instead of acknowledging the contrary binding precedent, he refused to give responsive answers because he knew it didn't support him. So this court should infer, because of that waffling, that he was doing this intentionally. And even if Schroeder did not know that his arguments were frivolous, like, you can be a dumb and bad lawyer. Doesn't mean you're malicious or, frivolous. Just be an idiot. That's not how the law works. Says that his arguments were frivolous. At a minimum, he recklessly maintained his frivolous arguments. So he should have known after he made it, like, I didn't know, then like, oh, I better fix that. It is not just that a reasonable attorney in his circumstances would have made a proper inquiry. He was on notice. This was all being brought under the INA. Now, his conduct, even without assuming knowledge, was thus a departure from the ordinary standard of care, and he made an obvious risk of material misrepresentation. He ignored that and continued on. But what we see is clear and convincing evidence shows this lawyer made frivolous filings for an improper purpose. His improper purpose is evident from the filings. After he lost his initial motions, he filed renewed motions. He filed transfer of venues. Cases were pending all over the place, but he just kept filing. He wanted to get him stopped anywhere. He just needed the judge somewhere to sign off on it. Now, a separate basis for finding of bad faith is Schroeder's obduracy. That's a good word. He was stubbornly persistent in making baseless arguments despite notice of all the facts. And he's still doing it. He's still appealing it, saying, I was right, you're wrong. Now, this court may sanction lawyers personally under certain circumstances, especially when there's a pattern of misconduct like we see here. And sanctions are also important to deter any other misconduct, especially when it's being done in bad faith. This is also, as we've seen from these immigration lawyers, gross disrespect for the law. What Schroeder has done is using the use of known falsehoods to try to further their advantages in court. Totally unethical and inappropriate. But that is what Schroeder has done. Having been warned multiple times that his client had a valid removal order, this lawyer nevertheless persisted in delaying the lawful execution of that order, claiming in other courts without any basis in fact the government was treating Lohr as an alien enemy. He refused to give straight answers, not only on June 7th, but also in failing to respond to our objections. This is not the conduct of a forthright but mistaken advocate. His evasiveness evidences knowledge of his guilt and his unwillingness to accept responsibility for his actions. And so, because of his pattern of knowing and his reckless misrepresentation has now extended to 3 separate courts, including you, he multiplied proceedings unnecessarily. He abused the judicial process for the improper purpose of trying to obstruct the enforcement of the immigration law like an insurrectionist. In short, none of what Schroeder has done is becoming of a lawyer, and he deserves substantial sanctions. Saying deterrence is especially important in cases like this because these are cases of national importance. Sanctions are especially warranted because this lawyer Schroeder's contentions may mislead the public and cause baseless concern about a topic of national importance, saying we're throwing people out of airplanes into the ocean. What? Removal under the proclamation and the AEA is an active area of litigation. Frivolously asserting that a valid INA removal is illegal is unnecessarily inflaming this entire conversation. And so, listen, court, it is essential. We must deter the attorneys from bringing baseless grounds to delay or defeat the enforcement of the law. It's a lack of respect for the law. This is of national importance, and if you fail to deter this guy and people like this, we're going to see the filing of similar actions all around the country, which we've seen, all trying to forestall these lawful removals. And so this is going to hamstring our ability to protect Americans and get rid of people with serious criminal histories who are threatening public safety. Now, it is thus crucial, court, to use impose substantial monetary sanctions, fines out of that booty, to deter widespread improper filings in removal cases like this one. And so you, court, should impose sanctions on Schroeder personally under the U.S. Code. The sanctions should include compensatory sanctions for the excess costs, expenses, and attorney's fees reasonably incurred because of his conduct. Man, that's going to be expensive too, because like multiple plane flights back and forth, pilots up, private, charters, get back up, back down, a lot. And this court should also impose non-monetary sanctions as well. Coming in from the U.S. DOJ, District of Guam and elsewhere, from Mikkel Schwab and Christopher Ian Pribby, trial attorneys, in against this attorney out of California, an individual now facing sanctions from the DOJ. So we'll see what the judge says about that. And I think even if the judge doesn't grant sanctions, which he may be disinclined to do, that this is a public scorn, right? This is the red scarlet letter. This is calling this dude out in public in a way that doesn't often happen from the DOJ. And, your name in law is basically everything. You have your reputation. You want to defend your integrity and your honor. And now when you have the DOJ coming out and putting on the record all of this stuff that you've done, he might think that he can get away with it, but now he's being called out. And this is happening not just in this case, but everywhere. We covered many immigration cases where they're just filing stuff. It's happening so quickly. Doesn't even seem like the judges are reading anything. So we'll keep our eye on this and other activity out of the DOJ. Thank you for subscribing and joining as we do.